President.
Senator from Vermont.
Mr. President, I ask consent the call of the quorum be dispensed with.
Without objection.
Mr. President, when the America Invents Act was first considered by the Senate last March, I spoke about the contributions Vermonters have made to innovation in America since the founding of our nation. The distinguished presiding officer and I know about what Vermont has done, but I remind everybody that from the first patent ever issued by our government to cutting-edge research and inventions produced today, Vermonters have been at the forefront of innovation since the nation's birth. Now, many may think of our Green Mountain State as being an unlikely hotbed of innovation, but we've actually in the last few years issued the most patents per capita of any state in the country, actually more patents than a lot of states larger than we are. It's a small state, to be sure, but it's one that's bursting with creativity. And the rich history of inventive spirit in Vermont is long and diverse. Vermonters throughout the state have pursued innovations from the time of the Industrial Revolution to the computer age. Vermont inventors discovered new ways to weigh large objects, but also how to enjoy the outdoors. They perfected new ways to traverse rivers and more environmentally friendly ways to live in our homes. Over the years, as America has grown and prospered, Vermont's innovative and creative spirit has made the lives of all Americans better, but also made them more productive. The patent system in this country has been the catalyst that spurred these inventors to take the risks necessary to bring these ideas to the marketplace. The story of innovation in Vermont is truly the American story. It's been driven by independent inventors and small businesses taking chances on new ideas. But a strong patent system allowed these ideas to flourish. They also brought our country unexpected and unprecedented, I should say, brought our country unprecedented economic growth. Now, these same kind of inventors still exist in Vermont today, as they do throughout our great country. But these inventors need to be assured that the patent system that served those that came before them and served them so well can do the same today. The America Invents Act will provide that assurance for years to come. Now, my distinguished colleague from Vermont and I have both spoken several times on the floor since the Senate came back in session about the devastation in Vermont. And I can't help but think of that devastation that Irene caused in so many of our communities at home. Just as Senator Sanders and Congressman Welch and Governor Shumlin, I've seen the damage and heartbreak firsthand. But I also saw the fruits of innovation that helped bring recovery to communities throughout Vermont. The heavy machinery that helped to clear debris that will rebuild our roads and our bridges and our homes. The helicopters that brought food and water to stranded residents. The bottles that allowed safe drinking water to reach them. The American patent system has helped to develop and refine countless technologies that drive our country in times of prosperity, but also in times of tragedy. It is critical that we ensure that that system remains the best in the world. Vermont and the rest of the country deserve the world's best patent system. The innovators of the past had exactly that. But we can assure the innovators that are among us today and those that will come in succeeding generations will have it as well by passing the America Invents Act. I'm proud of the inventive contribution that Vermonters have made since the founding of this country. I hope to honor their legacy, hope to inspire the next generation by securing the passage of this legislation. I've been here for a number of years, Mr. President, but this is one of those historic moments. The patent system is a few things enshrined in our Constitution. But it's also something that hasn't been updated for over half a century. We can do that. We can do that today our votes. We can complete this bill. We can send it to the President. The President has assured me he will sign it. And we'll make America stronger. We'll create jobs. We'll have a better system. And it won't cost the American taxpayers anything. That is something we ought to do. With that, Mr. President, I suggest the absence of the quorum, and
Clerk will call the roll.
Mr. Akako. Mr. Alexander.
Madam President,
Senator from Massachusetts,
I ask that proceedings of the quorum clause be dispensed with.
without objection.
Madam President, the parliamentary situation, how much time does Senator Cantwell have at this time?
"13 minutes remaining."
And it's my understanding Senator Cantwell wants to preserve a component of that, so I would, on behalf of Senator Cantwell, yield myself 5 minutes at this time.
Without objection.
Madam President, I appreciate the comments of our friend from Alabama, Senator Sessions, regarding his amendment to strike Section 37 of the Patent Reform Bill, but I disagree with him on substantive terms, and I ask our colleagues to look carefully at the substance of this amendment and at the importance of this amendment with respect to precedent, not for one company from Massachusetts or from one entity, but for companies all over the country, and for the application of patent law as it ought to be applied. The only thing that Section 37 does, the only thing, is to codify what a federal district court has already said and to implement what the United States Patent and Trademark Office is already doing. There's no breaking of new ground here. This is codifying a federal district court, codifying what the Patent Office has done, and in fact, codifying common sense. It's putting into effect what is the right decision with respect to how we treat patents in our country. Section 37 is in fact a very important clarification of a currently confusing deadline for filing patent term extension application under the Hatch-Waxman Act. And frankly, this is a clarification, I would say to the senator from Alabama, that benefits everybody in the country. In fact, this is a clarification which has already been put into effect for other types of patents that were once upon a time treated with the same anomaly. They rectified that. They haven't rectified it with respect to this particular section of patent law. So all we're doing in this is conforming to appropriate law, conforming to the standards the Patent Office applies, and conforming for all companies in the country, for any company that might be affected similarly. If this were a bailout for a single firm or a pharmaceutical company, as some have tried to suggest it might be, why in the world did a similar provision previously get reported out of the Senate Judiciary Committee by a vote of 14-2? How in the world could this provision then have passed the House of Representatives as it did? And why would many House Republicans have supported it as they did? The answer is very simple, because it's the right thing to do under the law and under the common sense of how we want patents treated in the filing process. The law as currently written, frankly, was being wrongly applied by the Patent and Trademark Office. And you don't have to take my word for that. That's what a federal court has said. On more than one occasion, each time the court has ruled that it was the Patent and Trademark Office, not an individual firm called WilmerHale or Medicines Company, not those two that made a mistake here. Now, let me make that very clear so the record is as clear as it can be here. The current law, as it's written, says that to obtain an extension of the term of a patent under this section, the owner of record of the patent or its agent shall submit an application to the director. Such an application may be only submitted within the 60-day period beginning on the date that the product received permission under the appropriate provision of law. Now, the FDA reasonably interprets this language to mean that if something is received after the close of business on a given business day, it is deemed to be received the next business day. Under this interpretation, the filing by the Medicines Company was indisputably timely. My colleagues should not come to the floor and take away from entities that are trying to compete and be in the marketplace over some technicality the suggestion that because something was filed electronically on a particular given day at 5 o'clock in the afternoon when people had gone home, they weren't open, that somehow they deemed that not to have been appropriately filed. But rather than accept that common sense interpretation, the Patent and Trademark Office told the medicines company that it was late. They just decided that. And then they said, you're late despite the fact that that interpretation contradicted the same business day rule that the FDA uses when interpreting the very same statute. So, as a result, Mr. President, Madam President, the issue went to court. And guess what? The court told the PTO that it was wrong. A federal judge found that the Patent Office and FDA had been applying inconsistent interpretations of the exact same statutory language in the Hatch-Waxman Act. The FDA uses one interpretation that has the effect of extending its own internal deadlines, but the PTO insisted on using a different interpretation. And the result was, heads I win, tails you lose. And for companies investing in innovative medicines, the court found that the PTO failed to provide, I yield myself one additional minute.
Without objection.
It further found that the PTO's interpretation had the effect of depriving the applicants of a portion of their time for filing an application. After considering all the relevant factors, the court adopted the FDA's interpretation. So the court told the PTO that they were wrong, and it was them and not the medicines company that made a mistake. So, Madam President, this is not an earmark. It isn't, as Senator Sessions contends, a single company bailout. It's a codification of a court ruling. It's a clarification. It's common sense. It puts a sensible court decision into legislative language, and it is legislative language that applies to everybody across the country, to all companies equally. It doesn't single out any particular company, but amends the patent law for the benefit of all applicants. So I ask my colleagues to oppose the Sessions amendment on the merits. More importantly, we need to move forward with this important bill that Chairman Leahy and Senator Grassley have worked so hard on. Passing the Senate Sessions amendment would stop that. It would require a House-Senate conference on the bill, and it would at best seriously delay and at worst make it impossible to exact patent reform during this conference. So, Madam President, this is on the merits. This is for all companies. This is common sense. This is current law. This is current practice. And I ask my colleagues accordingly to vote appropriately. And, Madam President, I ask unanimous consent that at 4 p.m. the Senate proceed to the votes in relation to the amendments and passage of H.R. 1249, the America Invents Act, with all other provisions of the previous order remaining in effect, that the final 10 minutes of debate be equally divided between the chairman and ranking member of the Judiciary Committee or their designees, with the chairman controlling the final 5 minutes. Further, that there be 4 minutes equally divided between proponents and opponents prior to each vote.
Is there objection?